Thank you, everyone, for joining us for our first episode of Historically Speaking for this school year. We are super excited to have Dr. Mary Osborne, director of the Stewart House Museum, hosting this specifically. She prepared and did all of the research for this. We are also joined by Denise Rugani, our usual co-host. Denise is a former fraternity president, former history chair. I always forget that title and current ritual and history director. Mary Kate Cavanis, an alum from our Arkansas chapter, has agreed to produce and help watch the waiting room. So thank you, MK, for helping with that. She is our colleague in the foundation. Also exciting, Jill Luckin, our foundation executive director, has joined. So I am Kylie Smith. I'm the archivist and the museum director, and super thrilled that all of you are here with us. So Mary, whenever you are ready, you can hit it.
Hey, thanks, Kylie, and welcome to everybody. I'm so excited to be able to kick off our new season of Historically Speaking. On June 21st, 1898, Minnie Stewart died unexpectedly following an operation at a Cincinnati hospital. Her family laid her to rest in their plot in Monmouth, where her father's body had been interred just 6 months prior. Although her family grieved her loss, they could carry out her final wishes with certainty, as her affairs were already in order. As a judge's daughter, Minnie understood the importance of having a last will and testament. Once she passed away, her executor presented her will in probate court. He paid her debts and handled her bequests. What appeared to be a smooth process, however, was not always the case for women. When Minnie was born in 1852, many women in the US did not have the power to dictate a will, especially if they married. During the period 1830 to 1920, 90% or more of women over the age of 35 were married. Prior to the passage of property and will reforms beginning in the 1840s, a married woman fell under coverture laws. The system of coverture originated in British common law. Essentially, once a woman married, her legal and economic identities merged with her husband's. A married woman could not own or manage property, sign a legal contract, or appear in court without her husband's consent. Historian Linda Kerber argues that coverture assumed that married women possessed no independent mind. Single women, however, were treated as men under the law. Minnie wed her second husband, Lucius Field, in August 1889. They had been living in Eustis, Florida since December of that year. Minnie served as an assistant principal of a high school, while Lucius had worked a variety of jobs, including dabbling in growing citrus fruits. When Minnie died, her husband accompanied her body back to Monmouth for the funeral and burial. Minnie's marriage took place after most states had implemented property reform that benefited married women. Before these acts went into effect, wives had few recourses. There were, however, some loopholes in the law. Before marriage, the prospective bride's family could negotiate a settlement in which the woman's property might be set aside in trust so that her husband had no access to it. Additionally, the family could designate a third party to manage it, usually a male relative. Some women also negotiated for more autonomy in their settlements, such as the ability to make decisions about separate property. The definition of property included that which a woman owned before she married, property that she inherited, and gifts to her from anyone other than her husband. These might include real estate and personal property, such as clothing and household goods. Between 1839 and 1895, a series of acts allowed married women more freedom to dispose of property. For reference, Minnie's will was written in 1898, shortly before her death. Some of these laws were limited in scope and designed to serve the interests of fathers wishing to protect their estates from avaricious sons in law. Mississippi was the first state to guarantee the right of married women to receive income from their property and to protect it against being seized for their husband's debts. But the law left husbands in sole charge of buying, selling, and managing property. Other laws granted married women control of property but not ownership, meaning they could not alter or sell it. Southern women's testamentary rights were also challenged when it came to matters of manumitting enslaved persons. If a woman chose to emancipate her enslaved workers in her will, her male relatives could sue to have the will voided. An example of this type of challenge is the case of Jane Miller from Trigg County, Kentucky. An unmarried woman, Jane died in 1858. Her will specified that her enslaved workers be set free, but her brother Isaac brought a lawsuit to the Trigg County courts. He alleged that his sister was insane, so her will should be declared void. Although the county courts ruled in Isaac's favor, the Kentucky Court of Appeals overturned that ruling in 1864. Judges stated they found no evidence that her behavior suggested a sexual disorder, as her brother claimed. Jane had met all the requirements to write a valid will. She had possessed sufficient capacity to understand the extent and condition of her property. She recognized her relatives as being her natural heirs, and she had a fixed purpose in mind when devising her property. Cases such as Jane Miller's indicate that a will signified more than the transmission of wealth. They were about relationships. Scholars generally point to New York as the first state to pass comprehensive property reform in 1848. New York's law served as a model for similar acts passed between 1848 and 1895 across the country. In addition to property a woman owned prior to her marriage, the New York law also accounted for any property she might acquire during marriage. By 1920, all states had passed some type of reform allowing married women to bequeath property in a separate will without their husband's permission. Before we examine Minnie's will in more detail, let's look at her father, James, for comparison. Judge Stewart's will was written in 1890. He designated his wife Isabel and his son William his executors. Property that he owned in Aledo, which is a town north of Monmouth, was held in trust for his children to be divided equally among them. This phrase illustrates the principle of paritable inheritance. Since achieving independence from Great Britain, the United States chose not to follow the laws of primogeniture, in which the oldest son was automatically made the sole heir. Instead, James was generous towards all his children. Minnie and her older sister Isabel both received $100. Now, that sum may seem like a small amount, but remember, both Minnie and her sister were married with rights to their husbands' estates. The Stuarts' primary residence passed to William. The residue of the judge's estate was bequeathed to his wife Isabel. As is the case with Minnie's will, the Stuarts provided well for their families. Minnie bequeathed her estate in Eustis, Florida, to her husband Lucius, but her property in Illinois was to fall under the control of her brother William, with the proceeds going to her husband. In the event of their deaths, her estate was to go to her sister Isabel and then to Isabel's children, Daniel and Eleanor. For unmarried women, the law worked differently. Single women were treated the same way as men under the law. They, however, faced their own set of challenges, chiefly to whom to leave their estate if they had no heirs. Intestacy laws, or those laws determining what happens to a person's estate when there is no will, favor the close relatives of the deceased. However, a testator could also designate a charity as her beneficiary. Testators also viewed donating to charities as an expression of their identities. Others included these bequests as a way to achieve a kind of immortality. The law strictly defined a charity as an organization benefiting society in some way. The law, in fact, takes a very broad definition of the word charitable. An organization does not have to help the needy in order to benefit society. Designating a charity as a beneficiary is not common among Americans, and it was rare during Minnie Stewart's era as well. Lawrence Friedman, who has studied the social history of wills and inheritance law, reports that an old study of wills in New York County from 1880 to 1885 revealed that only 8.4% of wills made any provision for charity. This study included the estates of wealthy individuals, too. Very wealthy individuals, though, were expected to set up a foundation. Minnie Stewart's sister-in-law, Ada Mariner, was not a wealthy woman, but at the time of her death in 1937, she was unmarried and had no children. She had property in Bliss, Idaho, and assets from her career as what we might call a real estate developer today. Her case exemplifies some of the conditions we have just discussed. Ada's will, dated May 17th, 1932, stipulated that a house she owned in Idaho should go to an acquaintance named Jane Toma. She directed that the remainder of her estate to be divided equally between her nieces, Lucretia and Isabel. These were William Stewart's daughters. I would argue that this clause represents a reconciliation between the women. Interestingly, Ada later issued a codicil to her will in 1933, which revoked the bequest to Jane Toma. And I could not find any reason as to if there was a falling out or why she issued that codicil. So that'll have to remain a mystery for now. Newspapers also indicate that Ada bequeathed her hotel in Bliss to the local Grange to use as a meeting place. Charitable giving was heavily scrutinized in the 19th and early 20th centuries. As a result, most states at one time had mortmain statutes in place. Mortmain literally means dead hand in French. Originally, these laws protected families against the dying's fear of hellfire. They limited an individual's ability to make transfers of property to religious and other charitable organizations. The courts could declare a gift to charity invalid if a will was made too soon before death. They could additionally prevent the establishment of perpetual charitable trusts. Only close relatives could challenge these provisions. When Lucretia and Isabel Stewart's maternal grandfather, Henry Mariner, issued a codicil to his will, which revised the conditions of his granddaughter's inheritance in favor of his daughter Ada, they challenged the validity of the codicil in court. They sued their aunt in 1907, alleging that she had coerced her father and caused him mental and emotional distress. The judge ruled in Ada's favor and dismissed the lawsuit. None of these women we have discussed so far possessed large estates, but I want to conclude by examining the will of Tade Hartsuff Coons, Kappa Kappa Gamma's first grand president. Tade was a member of Mu chapter at Butler University. She was well-traveled, and by the time she made her will in 1933, she had acquired a large estate. Tade left the majority of her possessions to her nieces, nephews, and friends. What makes her will interesting is that it exemplifies how property reform had changed women's lives. Tate had stocks and bonds to dispose of, in addition to material possessions. Furthermore, she bequeathed her portrait, painted by Elizabeth Gowdy Baker from Monmouth, as well as one of her dresses to the fraternity. She also donated over $10,000 from her estate to the fraternity for the Rose McGill Fund, Student Aid Fund, and the Endowment Fund, respectively. Tade wanted to ensure that the organization she had helped to grow would continue to provide for its members. Having no children of her own, she wanted to make sure that her sisters were looked after. Her will also illustrates the desire of many wealthy people to leave some kind of legacy. Her portrait still hangs in the fraternity headquarters and is highlighted on tours. During the course of the 20th century, states repealed mortmain statutes, and by the year 2000, none remained in effect. Today, individuals are free to establish lasting trusts for whatever charitable purpose they choose.
Thank you, Oz. On that note, as we have mentioned, August is Make a Will Month, and the timing for me is perfect. Having served as an executor before and working for the foundation for 25 years, I'm a bit delayed, but Jeff and I finally made an appointment to have our own paperwork drawn up. We called last April, and the first available appointment was in August. We are not exactly the millionaires next door, but we both realize that we want to make sure our affairs are in order. I mean, who's going to take care of Chester, the faux feral cat who hangs around our barn if we suddenly disappear? So don't worry, our attorney put that in our documents. She also put Kappa in our documents. When someone chooses to include the Kappa Foundation in their estate plans and lets us know about it with an estimated gift amount, you become a member of the Omega Society. Even if you already have one of the older Omega Society pins, we've recently rebranded the program, and existing members who have shared the details of their plans with us, as well as new members who do the same, will receive one of these gorgeous new pins, as well as a print of the Iris watercolor Togetherness by Julie Dawson. Members of the Omega Society recognize that the work of Kappa extends well beyond a lifetime and want to continue to make an impact after they're gone. All of us can help ensure that future members continue to benefit from the programs, scholarships, and opportunities that we care about today. In fact, the Stewart House Museum is secure long into the future because of the support of so many, but most recently because Marianne Lyon, a Kappa from Texas and longtime volunteer, wanted to make sure we could keep paying the water bill, maintain the roof, and many other things. Her estate gift was an incredible surprise, and I only wish that we had known about it while she was still with us so that we could give her a proper thank you. Making an estate gift can be as simple as adding Kappa as a beneficiary or including the foundation in a will or trust. And every gift can be shaped around what feels right for you. If you've already included Kappa in your plans, or if you're just curious about what that could look like, let us know. It's a lot easier than I realized. And even before we met with an attorney, I learned that I could simply list Kappa as a beneficiary on the life insurance policy that I receive as an employee. So while we receive estate gifts here and there as wonderful surprises, if you tell us about it, we can then tell you how grateful we are in real time. And that's the very best part. For these historically speaking programs, we do a bit of history at the beginning and a bit of ritual at the end. We try really hard to keep it to 30 minutes. So any questions for Denise or Dr. Oz or Jill, because you're going to write your $10 million check to the foundation. And the other Jill.
Exactly, the other Jill.
Well, this has been marvelous. Thank you again, Oz, for all of your research. You can tell who the professor is in the room. Thank you, Denise, for covering ritual for us. And thanks to all of you for joining us. Our next episode is coming up on Tuesday, September 29th. So we'll be promoting that on social media. All of the recordings for these programs are going to, it'll usually takes me about a week or two to get them fully edited and posted to the fraternity's YouTube channel, but it will be there eventually. And our topic next month are questions that we gathered at convention. So we had an opportunity for folks to write on Post-it notes questions that they were curious about. Of course, everyone wanted to know, why do we wear white at convention? Why were we This one I thought was interesting. We all just kind of accept it for what it is, but the question was, why were we established at Monmouth? And so we know the answer to that. Dr. Oz has done some research for previous programs and projects, and so we have some cool answers for Kappa 101. I think that's that's what we're calling it for the mishmash of questions that we have received. So thank you again for joining us tonight. Thanks, Oz and Denise, and we will see you all next month.
Thank you.